Good, good. Okay. All right. Well, let's kick off. This
Hmm.
is the Law FIDAO Establishment Subcommittee meeting for the 7th of October. Uh, if you have any issue with being recorded now or subsequently, please send an email to jp@lawfidao.com.au. The privacy notice and the consent notice is always in the YouTube channel as well to remind you if you need to get in touch with me subsequently to edit any material. So today, as Andrew, you raised last week, the topic is insurance cover and really what the key risks are for Law FIDAO that we think or we feel we should be attempting to secure insurance for or bringing to the top of discussions in attempting to get insurance cover. So, Andrew, I'll just hand over to you initially to share with us any reactions that you had from the particular section in the white paper. And then the program that I've got is I've made a bit of a list of potential claims from various stakeholders and the nature of which those claims, as well as some geographic considerations. Um, so if that's okay with you, might hand over to you to make some opening remarks before we get into it.
Sure. I just have to find the right page.
That's okay. Well, then, while you're finding it, I should give the summary then that the aim for the pay to rely. Hi, Nathan. For the pay to rely model is that Law FIDAO provides that as a protocol. And that is the operational or a key pillar operational protocol of Law FIDAO. And in that sense, you could look at Law FIDAO more as a platform rather than part and parcel of each qualified lawyer giving the advice. And what we're trying to establish here is that it's really just a piece of technology or a tool that each lawyer or law firm can access and use in order to have direct client relationships. So if I, through Bedazzle, am a contributor and and launch a pay to rely product using the Law FIDAO protocol, Vic, you might be one of the people that seeks to purchase and pay to rely. So the protocol establishes a direct relationship between myself, Bedazzle, and Vic, and therefore the protocol is just that facilitative tool. It shouldn't, I mean, it will seek to guide and it will seek to support qualified and registered lawyers to use the pay to rely protocol, but it's not involved in that commercial bargain other than again, the automation of the revenue split as between the core contributor, the peer reviewers, the self-insurance pool, and this black box pool, which we don't know whether it will be for grant making internally, for Law FIDAO purposes, or to further the Law FIDAO purposes that grants are made to other deductible gift recipients or other registered charities, or if it forms some sort of revenue distribution scheme. And that's being the critical point of whether there's an objective gain for members if they staked their NFT or another associated token to receive a portion of those revenue distributions. And question how that would still apply if a separate token was allocated in a completely separate contractual capacity that you could stake and earn revenue distributions. So the platform, to that extent, could facilitate maybe profit or gain, but not necessarily of members, because you may not have to be a member to participate in a revenue distribution. But that's what we're really trying to flesh out through the ASIC early engagement and through hopefully a consensus of lawyers that are willing to provide independent legal advice to Law FIDAO. And that probably gives the framing as to, what are the applicable laws in all of the jurisdictions that could give rise to insurance claims. And if some of the revenue share is going to a a self-insurance pool, is it just as a conservative measure in the event that Bedazzle, for example, is the core contributor, I might have a $2 million liability cap, but the harm that my advice, my pay to rely advice, may have caused is in excess of $2 million. So by virtue of the pay to rely product facilitating the one to many, I really liked how you put that, Vic. It's many direct relationships that escalates a lawyer's and a law firm's exposure. Should it be the responsibility of the platform to ensure some of that risk with the revenue that's collected? But noting that if it really goes back to benefit Bedazzle in this case, then maybe that revenue share should be held in a specific escrow account for that particular lawyer and law firm. So a segregated sort of reserve basis rather than a commingled basis on behalf of everyone. So that sort of gives some articulation of the substance of the potential activities of Law Fight Out if they're approved at our general meeting next week. And then, so I know, Vic, you've got your hand up, but I'll just hand over to Andrew to see if you're in a position to speak and give some perspectives.
Yeah, thanks, Joni. Well, my perspective is, as we've talked about before, not coming from a legal perspective. So take it for what it is. Look at it just at the broader picture. And I think there's a couple of pieces to consider at play here. So we really need Rick involved from a contextual point of view in terms of how to assess risk, because that's ultimately what the insurers are going to be doing. And certainly in the exploration we've done, insurers are not at that step yet. We've looked at how is at a fun, and I'll go off piste a little bit just to bring it back, is if you look at all the work that's been done on metaverses today, for example, which are super nascent and very exciting and all the rest of it, but that risk is not priced into this. Insurance is not priced in at all. And yet this is something that could well have 4 billion users within the next 3 or 4 years. So you say, well, that's interesting. So the work that Rick is doing is important here, as I think everybody that's tried to do anything with professional indemnity has found that's always the challenge. Whether you're a lawyer or an accountant, or whether you're just providing professional services and advisory in general, the very, very risk averse. So I think new forms of actuarial work, which is some of the stuff that Rick's working on, and particularly with running data sets and synthetic AIs and stuff like that, I think that will be really, really helpful as that starts to evolve. What I saw when I read the white paper from in this tokenization, in this pay to rely piece, where that mirrored from the work we're doing, is it's got very close similarities to a program we called DAS, so Dynamic Attribution and Allocation System, which is something that we've got, again, it's nascent. We've built it out in a manual analog form, but it'll need significant investment to bring it up into an automated system. But in basic principles, what it is it's addressing the problem, and this isn't directly from the lawyer perspective, but it could also apply here, and we looked at it from the entrepreneurial perspective, that often people hold back from providing their input, be it wisdom, be it experience, be it a particular idea or whatever, on the basis of a fear of missing out, that they're going to get stuffed over. And it's a common trait that holds things back. And so we sat down at a philosophical level and thought, well, what could we do, and what does technology make possible to be able to address some of those things. And what our working thesis that we've developed is this DAS program, which basically has two algorithms. The first one, which I think directly replies to what Pay to Rely is looking at, is it establishes an attribution algorithm. So then there's a whole series of definitions as to what makes a contribution, and this is all stuff to work through and to adapt to. But time would be one thing, wisdom would be another. There's a whole lot of different things that can come into a contribution point, and how an idea evolves and is added to create a whole. And in the case of the Pay to Rely model, obviously the work you're putting in as an individual lawyer to provide a pool that is then in a position to be reviewed, the strength of that advice is based on everybody contributing both in the original authorship, but then in all the editing, the review, etc., etc. So it's a complex amalgam of contribution, if you like. So what we see in the attribution algorithm is effectively a no-value token. So what it's doing is it's giving you a stake in the size of a pie, if you like. And what still needs to be worked through, and I think there's probably different models in this, is the pie one size that is then fractionalized down? Is it a growing pie? What are people going into with their understanding in terms of what promise they're getting for their allocation, and working through all those areas? So this is nascent, but we're looking at some of the challenges of how to deal with this right now. Okay, so
Yeah.
so effectively yes, sorry.
Just to pause at that moment and also say it's not necessarily just the pay to rely model. This is also the debate going on with stable coins and whether a one-to-one reserve is enough, or if somebody who wants custody, basically stable coins with an Australian deposit-taking institution holding the reserve assets, whether if there's no federal deposit insurance scheme or no insurance scheme, the person should actually be required to pay $1.10 for every one stable coin they mint, which maybe is matched by another dollar by the bank's equity reserves or other profit reserves to subsidize the potentially systemic effects of that stable coin being in operation and losing its peg, or for whatever reason, if there's risk taken in other aspects of the reserves, that the insurance is there as a backstop to at least give you, 60% of a payback if more of the reserves can't be recovered. So I just wanted to add a broader contextual element that it's applicable to more things in Web3. Sorry, continue, and then we'll move to you.
Absolutely. And I think what's behind that, the desire for regulators to protect the consumer, the user, whatever, and that's that really, when you put it back into the DAO context, is what we've talked about. That's a functional equivalence and a regulatory equivalence of protecting consumer rights, etc., etc. So that's all fine. It's more a question of how is it done and how is it architected, and this is an evolving process. So we've now got our bucket. And again, these DAS containers, these things, there can be multiple, there can be a specific type, there can be different forms of contribution. So a pay to rely model, for example, will work on one level. You've got the legal advice, then you've got the, how's it promoted? How's it monetized? So there's probably different people contributing in a different way at a weighting that is yet to be determined. So that's something that provides the framework for the levers for people to have the argy-bargy as to which pool of the bucket, which subset gets what value out of that initial allocation. But it's against attribution, so you've still got it doesn't monetize at that level. You get X amount of tokens, so there might be 1,000 tokens and you might have 100 of those tokens because you've done blah 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 and you've met the rule. Doesn't become.
Can I just clarify?
Yep.
So even though it's a non-value token, it's pregnant with potential liability if you're
Yes,
attributed.
yes. So you've got you've got this contribution, this attribution, if you like, but with attribution, you haven't got to the benefits yet because the benefit is in the monetization state. But it is assuming risk with that attribution as well. So if you've got 10% of that particular bucket, in theory, you've got 10% of the liability as well. So it's a checks and balances thing. So you can see how complicated this is and how ultimately it's likely to require some sort of AI model over the top, I think, to be able to manage it. And to be able to give that line of sight and those sorts of things. But absolutely, you've got the attribution, but with that, your potential benefits are laid out by this non-valued token, but so are your future liabilities. So you've got both sides, okay? And then the piece that monetizes is a separate interlocking model algorithm that then applies a value, whatever that value might be, to that particular thing, that particular bucket, and then how that transactions, how you as a holder of your tokens use your tokens, whether you keep them in a wallet, and you could have them in a trust, you could have them in an amalgamated wallet, whatever. These are all the things to work through in terms of the design components, but effectively think of it as like a switching system, like a circuit board in a way. You either give, you can give people access to your particular contribution, and they can, through this other algorithm, they can pay for that access. They can pay to look at we'll call it a vault. It's not a vault, but it's kind of a vault in terms of what have I got in there, what content in my vault do I want to share with people or make available for people to have a look at, and B, how can they access that and use that and pay me for it? So these are the concepts that are all being worked through. So
Yeah, fantastic. Thank you for taking us through that. Vic, I'll go to you.
Thank you for that explanation. I'm still trying to keep up with what's going on. Oh my goodness. Okay, I have some questions. And this is sort of looking at it from the paradigm of like the conversations that I've had with regulators and sort of what's analogous in the market or what they understand, and how there's points of difference in the pay to rely model. There seems to be a couple of things that make the provision of advice in this context more or less risky and of greater benefit to the lawyers that would otherwise be assuming risk under a traditional arrangement. And I want to like just identify them and just get your thoughts on that, and yours too, Jenny, or anyone on the call. We are all very aware that this is experimental technology and it's being applied in an environment where the laws are either indeterminate, in a process of being developed, and regulatory guidance is somewhat present or absolutely absent. So the context is uncertain, for want of a better word. The things that I think make the pay to rely model a sensible and pragmatic approach are the following three: the network effect and the strength of an advice that is adopted as the correct view. And that's sort of, that seems to be valuable because the number of lawyers that are available to assess and provide advice in this environment is few. The differences of opinions hopefully will find some sort of middling ground, and the people that the industry, our peers that seek to rely on the advice, will hopefully gather around the correct view. Now, there's always the possibility that the popular view is not the correct view, correct being a subjective assessment, but there's very much a there's something of strength around anchoring to and creating a consensus viewpoint that is then adopted at scale. And that sort of boils down to like law being codification of social norms within this little particular paradigm. The second one was the peer review component. I feel very strongly that this galvanizes the advice and produces more robust and rigorous advice that's stress tested by other expert lawyers. They're already in, small supply. Just thinking about like the challenges of having consensus around specialist advice in this area, like access to it is almost impossible. The lawyers that work on this work are, not available. They're really busy. So having something in the market where you can actually have a peer-reviewed model against your advice just seems so valuable and completely differentiates this model of providing advice from anything else that's, presently available. In fact, it's just not. And then the third thing was, and this is sort of consistent with like what happens in sort of indeterminate areas of law, the advice is a very narrowly defined precondition of publicly available information. The thing that sort of differentiates the Peter-Outline model from the provision of, a letter advice is that it can expire on the change of factual scenarios. It can actually be pulled, it can, or have a due date or an expiry date, where you don't see that happen in the form of, a letter advice conveyed by email. There were the three things that I sort of wanted to raise. And Joni, please correct me if my assessment is wrong, if you want to add something. But in my mind, these are really pragmatic and really valuable elements of the model that are of greater benefit to the lawyers that are producing advice that need to sort of de-risk or, down risk the provision of advice in such a nascent area of law.
Well, I completely agree with all of your points. And just to illustrate that through one of the examples, so amongst tax lawyers, there is a level of consensus, Australian tax lawyers at least, that following the El Salvador declaration of Bitcoin as legal tender, that we could treat Bitcoin as foreign currency for tax purposes. And in all of my early engagement with the ATO on behalf of other clients, they continued to knock me back, that they didn't feel that was the case. And then 6 months later, we have the exposure draft legislation from Treasury saying, we do think that we need to clarify that the policy intent was never to treat Bitcoin as a foreign currency. Now, so you've had this social consensus form, at least amongst tax practitioners, that this election, the foreign currency elections should be able to be made for say a Bitcoin miner to keep their accounts in Bitcoin if that's what they're predominantly dealing with. And there's other human rights aspects to it, which are all in the Bedazzle submission. But yet you've got government disagreeing with the consensus, and that consensus could have eventuated through the peer review model too. And so that's probably what results in a claim risk if all of those taxpayers did rely on the pay to rely, advice, and then that was peer reviewed. And then there's a subsequent law change, and the proposed law change was to have retrospective effect so that nobody could take advantage of that tax position. It exposes the core contributor, the peer reviewers, and potentially LawFi as a platform to, and the members, all of which who voted on the protocol to be deployed, for example, that exposes us to potentially the tax shortfall owing now from all those taxpayers, plus any penalties and interest. Now, maybe you assume that there's no penalties and interest because the pay to rely product maybe meets the standard of what we call a reasonably arguable position paper. But you've still got probably significant tax shortfalls for which all those taxpayers would want to claim the compensation, so to speak. And so how that's a reasonable risk. Maybe it's remote, but I think you could find that sort of similar fact pattern come about as we get more clarifications of law and new law. So that is
Yeah.
an example to tell you that's hopefully that's an insurable risk, or maybe it's not.
It would also be a pretty it's a remarkable would be a remarkable legislative implementation of retroactive um, uh, enforcement. So there would be like really adverse outcomes coming out of the implementation of that new law. Would you be able to argue some form of is there an argument against its implementation because of the adverse outcome for the collective pool?
Well, perhaps the peer review part of the pay to rely model could help prove that any new legislation should have prospective impact only and grandfathering or transitional relief to properly transition taxpayers. Because I think taxpayers should be able to choose to pay for the tax advice if they want to have a legal interpretation of the law as it stands. And, they can allocate resources as it stands. Nobody really knows how quickly policy reform will move. So why should they be held in abeyance? And sort of subject to the ebbs and flows of political processes. And that peer review, in a sense, makes it more of a case for prospective, but it's still a risk that all of us are exposed to. So maybe through the attribution model, if we have that algorithm running, we can say, Bedazzle wears 20% of this risk, Vic through alt law, 30%. Like, I'm just pulling these numbers out of my head. But in that case, each of our own individual insurances perhaps won't cover the tax shortfall. And that's where hopefully we could rely on this extra insurance pool. And otherwise, we contractually cap the limitation and say it's not payable in the event of law change.
You'd cap that. What about caps as to the number of people that can rely on a piece of advice? Because that might be something that lawyers that are providing the advice or members of the peer review group would want to have some form of control over. Like, it's all well and good to produce an advice and put it out into the world and be super happy that 10 or 15 people rely on it, but if overnight it becomes something where 150,000 do, well, your risk exposure is totally different.
And that's probably where we need to talk about whether there's a data collection step as part of a customer seeking to purchase a pay to rely product, where it says if the product was Bedazzle says you can make foreign currency election, then they also have to say what is the potential size of the maximum size of the tax saving, for example, that you would get from making this election. So you are in real time collecting the data of the size of the risk that needs to be insured, which could then be communicated to the insurer to adjust. Well, either the insurer or our self-insurance pool to adjust settings, such as if the likes of Zero Cap are managing the assets of our insurance pool, and they need to pull back and be more conservative rather than aggressive.
Yeah. What about also the price for the advice relative to the size of their risk that it seeks to provide the advice in?
Okay. Exactly.
Interesting. Oh my gosh.
I think again, this is there's some context here to get from Rick's input, and I look at this from the point of view of, well, what's the insurance company trying to do? So in any type of insurance, well, they're trying to get business development and find a new revenue stream. So yes, they want to do that. But they want to do that in such a way that they manage as much of their risk of payout as possible in the collection of the information for them to be able to make a decision, an informed decision on what risk they're willing to build into a policy. Now, I reckon I'd be I'd go out on a limb here, but I reckon there's probably no insurance company that has really, really, really thought through what the complexity and opportunities are in this space, in the digital space. I know just looking at dumb, simple things like we've reached out about how insurance companies insure for ESG and various other things over the course of the last year, and nobody wants to know. Nobody wants to talk to you about anything in that area. So the chances of them having really thought through what they're looking at doing for digital organisations is very close to zero, I would say, which is why having somebody like Rick on the team is really important, because it means that he can really push the edges, and as an actuary and as an AI actuary, he can start shaping up, well, I can make any of the people on this call can't make the passionate plea in the right language to the big insurers or a particular area within the insurers' companies to really say, hey, take notice. This is something that we can build as a competitive advantage. My sense is he can, and that's what he's looking to do. So I think that, as with all of these things, it comes back to what's in it for them. How does it work out? Now, the concept of working with peer review, making legal advice more affordable, more accessible to people. I reckon you could make an argument for, in the current paradigm, of that being part of the S of ESG. It's a social benefit to be able to do that. So those sorts of things can be thought through at a narrative level as to how they can go in. So I reckon we have Rick's off doing his work from his trip at the moment and putting together some shape there, but I think he'll add a real lot of value to what perspective can go to where in the marketplace. But this has a sense of, as much as most of the people in LawFi DAO are Australian at this point, it has a very international feel of the application here. And at best, we might be able to be used as a pilot, as a little petri dish. But the reality is, most of this is likely, from an adoption point of view, to be on a broader scale.
Yeah, and all I want to add to that is we may need to quarantine. You know, this came up in Vic's discussions with some of the legal services bodies, that if Bedazzle is contributing a pay-to-rely product, you know, I might say this is limited to token exchanges, for example, so that you limit the type of customer and therefore taxpayer that is relying on your advice. So you're starting to get to more of a specific circumstances set, and that gets you into legal services territory rather than perhaps legal information. But we may have to geographically cap then that only Australian qualified legal peer reviewers can participate in that, and how any sort of foreign registered lawyers may or may not want to or seek to or should have a say in that Australian policy or application of law.
Could you pass out, like, this is something that I think about over and over and over again. It is completely inconsistent with how you like a good, robust advice is likely going to take consideration of matters that are beyond the jurisdiction in which you're qualified to practice. That is just an artifact of the advices that we produce. So do you pass out a section of an advice, like, practically, and say, this is the area of law that, you know, this lawyer has provided advice on, this is the area of law that this lawyer has provided advice on, this is the advice, and then separately produce something that says, in the assessment of the advices, the following legal information is noted. It's not advice, and this is of a strategic nature for the recipient to consider the matrix of the context, broader context.
Well, and I think what you're referring to is, what is our international framework? Because, you know, it's not necessarily that one customer is only operating in Australia. They may want that same advice in the US and across Europe. And so we should be able to say, this is the Australian piece, but hey, lawyers in Europe, can you do the European version of this? And then whoever has paid for it in Australia, to the extent that Europe is relevant for them, they get notified, and they can fill out their sort of international tax compliance, in this case, risk management, by looking to, and that Law5 has that framework to bring the international together, like you say, is so necessary, at least in Web3.
It's such a, like, I can't emphasize, like, for the purpose of the call, but like if it's listened to in a recorded nature, I can't overemphasize the significance and the importance of having that analysis piece where you look at the different jurisdictions. It's a stilted advice if you go, this is UK, this is Australia, this is what's happening in Singapore. And without the solid assessment, this is the state of policy development, this is the pace at which we expect, new law to evolve or precipitate. These are the early indications of, enforcement action. Like, without that assessment piece of the whole puzzle, it's like, to me, it feels like a pointless advice. That's probably a harsh assessment, but like, the value in being a lawyer in producing something in collaboration with other lawyers from other jurisdictions cannot be overstated. But the robustness and value of the advice is in that final assessment piece. It's like, where does this look in terms of the broader lay of the land?
Completely agree. Nathan, if you're in a position to speak, I would love your perspective, if you can speak, but no worries if I put you on the spot.
No, I've just been listening for most of the call. I'm a bit lost this week. The only thing I'm thinking about in terms of that regulatory framework for the whole world, I'm sure. I think I thought I would have spoken to you about this journey, but layer C, something like that, where you could have some sort of mechanism to wrap a token with metadata that includes rules about what can and cannot be done. Just so that we can have something that can apply everywhere and just fit each wrapper to a different jurisdiction.
Yeah.
Otherwise, I'm just taking it all in still.
No, I love it. I love the concept of layer C. The question is to keep a protocol pure and as if it's a standard. The question is how many variables you put into that wrapper. So you might have modifications for securities law, but to do also tax law would be too much. So do you again have a further wrapper that says for this Australian security, then you put it in the tax wrapper? And I think that the legal advices that we do through the pay to rely product, V1, V2, maybe by the time we get to V3, it's compatible with the things that are coming to the market like layer C. But we're taking our baby steps.
Right.
But no, I love the comment. All right. The other thing on international frameworks, though, is in my experience with insurers and talking about directors and officers, association liability, professional indemnity type insurances, I have always gotten pushback on trying to include particularly Canada and then the rest of the US. Because they're, obviously the US has a reputation of being highly litigious, but obviously that is a huge market, but also increases risk and therefore potential premiums. But often, if you carve it out, you're more likely able to get some level of insurance cover. So just throwing that out to the group and seeing whether that's been your experience, and if so, what your initial reaction would be to geo-block those countries from participating in Law5 DAO.
Sometimes you've got to be pragmatic, and looking at the biggest animal in the cage, sometimes you don't want to deal with them.
Yeah.
If it's possible not to, move forward in other areas first.
Yeah, that's right. And once we've got a more reliable model, then slowly go into the US and Canadian markets. Vic, you want to say something?
Like my experience is from a completely separate area. It was looking at how to create a personal locator beacon, a new product to market. and then the insurance arrangements around it. And you can basically insure the entire world for a fraction of how much you can insure in the US. Nobody touches the US market. So, to create a global, like a really valuable piece of technology that saves people's lives, you can, create something that is safe for all of the world except the US. And I feel there's a parallel here, which is more entertaining than, useful. But
it kind of
what do we
describes
do?
the paradigm, because
Yeah,
the US entrepreneurs are described as high risk takers, and high risk, high reward.
yeah.
But also high litigation. So
everyone deserves a legal parachute. Like the reason we want to the broader objective is to encourage founders and startups at an earlier stage to engage with lawyers, to look at what their regulatory obligations are, to not hope that sticking in the pack and not sticking your thumb out too hard is the protection. Since when ever has that been the correct type of protection that we want to advocate for? So I still think that it's really valuable to include the US in considerations of international frameworks, and perhaps that we put greater limitations on the issue of the product into the US or to US founders. Like slap a bunch of like big disclaimers. They love caps over there, so why don't we just do it in caps, all caps? Change the fee structure. Consider other ways to balance the risk and the reward for the DAO and for the lawyers that are providing advice in that space.
Yeah, no, I agree. Well, I can see that we're at time, but there's still lots more to talk on insurance risks and potential claims. And we've only really just touched on the pay to rely model, not even anything about the design of the membership token. So is it okay if we hold this discussion over to next week? And the call next week will go ahead, and then hopefully see some of you in person at the ZeroCap office for the general meeting.
Sounds fine. Sounds good. Yeah.
Great. All right. Well, thank you for your time today, and see you next week.
See you next week.
Thanks, Jenny. See you later. See you guys.